Good afternoon and welcome to this, our ninth in the series of webinars. I really hope you've enjoyed the series so far. All of our webinars are recorded and shared on our website, as are the slides that the speakers provide. During the talk today, if you want to ask any questions, which I'll ask the speaker at the end, can you do so via the Q&A facility in the bottom toolbar on your screen. I'm delighted to welcome today Lorraine Cavanaugh Qc. She'll be well known to many of you as a leading practitioner in the Court of Protection. She's leading counsel in her field. She deals with very complex cases in the Court of Protection and in the family courts, including the inherent jurisdiction and the higher courts. She's often featured as counsel in very high-profile reported cases. She is to talk about serious medical treatment cases today. I welcome you, Lorraine Cavanaugh.
Thank you very much, Alison. At about half an hour ago, I came out of an advocates meeting and I went to get my slides to present them to you and found an old version. So I had for one of those horrifying half-hour moments that I might have to do something like interpretive dance for you for an hour because I didn't have my slides. But thankfully, a very computer literate member of Chambers assisted me to recover them. So let's start. Welcome. This is an excellent series. I've really enjoyed watching them online. And can I just say, on behalf of all of us who practice in the COP, a great deal of congratulations to Switalskis for putting this on. But not just that, thank you for putting this on. At this time where things are really very difficult for everybody and everybody is struggling just to get through, it's really nice to just have these things, just going back to some sense of normality, having lectures, engaging our brains after work about things that interest us all and of which we're all passionate about. And the very fact that each of you is here is a testament to your commitment to mental capacity work. And I'm very grateful for you coming, and I'm grateful to Switalskis for putting this on. I'm going to today, as Alison spoke to you about a moment ago, discuss serious medical treatment cases. It's very important at the time, whenever you look at serious medical treatment cases, to be very clear that none of the authorities, save for one or two, set out any principles. The importance and the guide at all times is the Mental Capacity Act and the framework under the Act. And that Act, as we know, has its structure around autonomy, around liberty, and around the person, and them stepping in to make a decision for themselves, and where they can't, doing one's very best using the structures under the Act to replicate the sort of decision that they might have made for themselves if they had all of the relevant information. So there are a number of cases that set out very clearly that just medical treatment is a particular area of intimacy for an individual. It's a matter that nobody else should be interfering in your personal choice about what treatment you're willing to accept, what violations to your body you're willing to have, and where you draw the line in your quality of life over your prolongation of your life. And also where you draw the line in what you're prepared to put yourself through, even if that does mean that you imperil your life. And those matters have been enshrined in case law throughout time, in truth, throughout the past few decades. Underpinning a lot of these cases is the strong presumption in favour of taking steps that prolong life. However, you have to recognise, and we all have to recognise, and the case law has over the past, I would say 3 or 4 years, moved really firmly into a position of not allowing the strong presumption in favour of preserving life to trump all considerations. And if we're all very honest, quite some time ago, there was a real sense in the case law that that was what was happening. I'm going to start, and the whole framework of this talk is going to be around some of the principles set out in the Serious Medical Treatment Guidance, which was issued by the Vice President, Mr. Justice Hayden, on the 17th of January, 2020. Well, doesn't that seem like a lifetime ago? And because it was issued literally about 6 to 8 weeks before a pandemic hit, a lot of other considerations and thoughts had to kick in, and other priorities. It's my experience that this has not been properly absorbed in terms of how important a document it is within the mental capacity community, legal community, and those working on the ground. To some extent, it has now started to be absorbed within the clinical population, but it is not necessarily yet filtered into the consciousness of all lawyers who act in this area of law. As an easy guide to what are the rules and principles, you can't do better than looking at the first 13 paragraphs of that document. It's a real distillation of the law for you. Everybody who picks it up thinks it's a procedural document very often and goes straight to the procedures as to what to do to issue one of these cases. But in truth, the first section of it is a very, very careful and helpful distillation of where your starting points are and what the principles are. So I have to ask you to read it really carefully. The guidance is only intended to operate until such time as there's a lot more clarity, hopefully, which we're going to get in the code of practice when it's revised. But as you know, we're all just waiting. Just because something is defined as serious medical treatment, I'll come quickly to definitions in a moment, doesn't mean that means it has to go to court. That's not the test, that's not the basis. There is no formal definition in the Act of serious medical treatment per se for all factors under the Act. There is one area in which there is some definition, and that falls within section 37. Now, I'm sure those of you have it to your fingertips will immediately know that section 37 is the section of the Act that looks at when an NHS body is looking at treatment, serious medical treatment for a person, and they are satisfied that person lacks capacity to consent to the treatment, they're satisfied that there is no other person engaged or providing care or treatment for that person for whom it would be appropriate to consult, then they are under a duty to appoint an advocate, an independent mental capacity advocate. Within that section, there is a definition at section 37.6, which says serious medical treatment means treatment which involves providing, withholding, or withdrawing treatment of a kind prescribed by the regulations. Okay, so let's go to the regulations. Regulation 4 of the MCA 2005 Independent Mental Capacity Advocates General Regulations 2006 provides the only statutory definition of serious medical treatment. And it is a statutory definition arguably confined to circumstances under section 37. So there isn't in truth a broad, pervasive definition of serious medical treatment in the legislation. And so the only one that we have, and you will see just how wide it is serious medical treatment is treatment which involves providing, withdrawing, or withholding treatment in circumstances where, one, in a case where single treatment is being proposed, there is a fine balance between its benefits to the patient and the burdens and risks. And number two, in a case where there is a choice of treatment, so then a decision between those treatments is finely balanced. Or a case that involves serious consequences to the patient. So if you think about it, that's a very wide definition of sorts of treatments that might fall under that. And they're not what you would immediately think of as treatments which are serious. Some of them might be quite lacking in seriousness, but they might be a fine balance of a decision on the risks. And those are matters that would technically fall under the advocacy section, but what we would not necessarily say needed to be treated in serious medical treatment for the purposes of allocation to a particular type or level of judge, for example. So turning to why this guidance was issued. This guidance was issued in the aftermath of the NHS Trust and Why case in the Supreme Court, which is a case where you know that it ultimately was concluded by, and the lead judgment's Lady Black, where the Mental Capacity Act is followed and any relevant professional guidances are observed. Obviously, that would include the code of practice. and the undertaking of the decision-making process is through the guidance and through the Act. If you get to an agreement at the end of that decision-making process as to the capacity of the person and their best interests, then in principle, medical treatment may be provided, withdrawn or withheld with the agreement that was arrived at after that lawful process under the Act without application. And of course, the cover for the clinician to protect them is Section 5. If you need to go back to it when you see the slides, you'll find the full quote setting that summary out at paragraph 126 of the judgment, so you'll have it there. Just going back slightly, if I may, under the guidance, the serious medical treatment guidance issued in January of last year by the Vice President, he states under the orders section, in every case, in addition to any declaration made under 16(1)(a), so if any of you have not got your thinking caps on, that's capacity, the court will consider whether the relief sought should be granted in the form of a declaration of lawfulness, so lawfulness in terms of the act to be done or not to be done in relation to P. And so that's the declaration of lawfulness under 15(1)(c), and stroke or a decision under 16(2)(a), an order to underpin that in some way. So the court requires a process of thinking about not just making your declarations, what declarations of lawfulness might be required, and do they need to be underpinned by an order, in short. Necessity then. Necessity, of course, provides the defence for medical professionals carrying out a relevant act, where they reasonably believe the person in question to lack the relevant capacity to consent to the medical treatment or to the cessation of that, and that the act in question is in their best interest, and that's obviously also on reasonable belief. Necessity, of course, isn't always a defence. And the medical treatment guidance sets out circumstances in which it probably wouldn't amount to a sufficient defence, which might lead a clinician or a trust to think that they need to bring this case to court. So necessity might not be a defence if at the conclusion of that medical decision-making process that we just went through, compliant with the Medical Capacity Act, compliant with relevant clinical guidance and compliant with the guidance under the code of practice, then at the end of that, if there remains concern that though there's agreement, it's a very finely balanced one. It's finely balanced. Or there is a difference of medical opinion, albeit a consensus might have been reached in the meeting. Or a lack of agreement, that's another circumstance, to the proposed course of action from those with an interest in the person's welfare. So even if the people at the meeting agreed, and for example, let's say you had an individual whose children had agreed with the clinicians in a best interest decision-making process, fully compliant, that it was in the best interest of that individual for clinically assisted nutrition and hydration to be withdrawn, and they'd received the relevant medical advice. But that the stepmother of those adult children, but the second wife of the individual concerned, for example, P, doesn't believe it. It doesn't believe in it. And even if they're not married, perhaps a girlfriend who doesn't perhaps have the sort of status or doesn't wish to press in on such meetings, if she feels strongly that this is wrong, that's a relevant section of views. That's a relevant diversion from the agreement. And in those circumstances, the guidance tells everybody concerned that it is highly probable that such an application is going to have to come to the Court of Protection. You absolutely must always give consideration to whether you're going to go to the Court of Protection, even if there's an agreement in the aftermath of a decision-making process that is lawful. And even if these factors don't apply, they should always ask themselves the question, do we need to go to the COP? And they can conclude not. But here, it'd be highly probable that they did if any of those circumstances occur. So that's in paragraph 8 of the guidance. And what is said here in the guidance at the next paragraph is that where any of the matters at paragraph 8 above arise and the decision relates to provision of life-sustaining treatment, an application to the Court of Protection must be made. So if you can see, if we just go back, in fact, I can't go back on my slides, forgive me, it's my fault. If the decision in question was finely balanced or any of those issues, and it relates to life-sustaining medical treatment, the guidance from the Vice President of the Court of Protection is you must come to court, even if you're agreed. It's only guidance, it's not mandatory, but it is expressed in very clear terms. And obviously, those acting for statutory bodies need to have very good reasons for departing from guidance, because of course, sometimes in due course, if decisions like that go wrong and people reflect back on why you made them, then you need to have very clear rationale for doing so. The other aspect, moving on through the guidance, so where we're looking to come to court, is any case which is not about life-sustaining medical treatments. Let's put those to one side for a moment, but involves a serious interference with a person's rights. Well, what does that mean? So first of all, I'll come to what it means in a minute, but if you get such a situation, it's highly probable, again, that you need to come to the Court of Protection to deal with it. There's a quote there from P, Sexual Relations Contraception, and even if you have agreement between all of the relevant individuals at a best interest meeting at the hospital, but for example, and these are specified in the guidance, where a medical procedure or treatment is for the primary purpose of sterilisation, that would be a significant interference with one's convention rights, where the medical procedure is supposed to be performed on a person who lacks capacity to consent to it, but it is for the purposes of donation of an organ, bone marrow, stem cells, tissue, or bodily fluid to another person. So not primarily for their benefit, but for the benefit of another. That should come to the Court of Protection. A procedure for covert insertion of a contraceptive device or other means of contraception. You can see that these cases hit the absolute nail of very serious violations potentially of somebody's rights if they're not necessarily decisions that are in their best interests. So these are not things that other people can easily settle for them without coming to the Court of Protection, is what the guidance says. Now, this isn't intended to be an exhaustive list, but it's tended to give you a really clear steer as to which type of cases fall within that sort of definition. So, for example, an ethical question, perhaps a controversial area of medicine, or an unlicensed medicine or something of that character. The guidance also just sets out very, very simply that separately to the matters elsewhere, an application to the court may also be required. That's not mandatory, where the proposed procedure requires a degree of force or restraint. And that goes beyond something that it's considered the parameters of Section 5 allow. Oh, forgive me. That's unfortunate that my phone's ringing. I should have unplugged it. So it requires to be stated, I think, clearly that the Court of Protection needs to be approached if they just assess that it's the right thing to do in circumstances where they are concerned that force is going to be used or a deprivation of liberty is going to be required that isn't immediately necessary within the meaning of Section 5. So judicial allocation of these cases, and this is the only aspect of procedure I'm going to turn to. I'm going to move on then to some of the more substantive merit-based case law on serious medical treatment. But turning just about to judicial allocation. In truth, serious medical treatment decisions or decisions in respect of an ethical dilemma in an untested area must be conducted by a Tier 3 judge. Otherwise, there will be a gatekeeping process as set out elsewhere in the rules and the practice directions, and really the things that the gatekeeper is going to be looking at there to decide which level of judge is appropriate is the seriousness of the consequences for the protected person of the treatment that's being proposed, and the seriousness of the interference with their rights. So just looking at some of those factors that we've just been to. So where's your starting point on best interests? It's James. It's Aintree University Hospital Foundation Trust in James. That's the Supreme Court, and I think this is where you can probably say that there are the basic principles set out. And every skeleton argument, every case you see on this, in truth, is going to have these principles set out. And there are a few really key paragraphs that you will see in almost every case. Paragraph 39 is a very important one. And it's just a reminder to all of us that we're dealing about this particular patient at this particular point in time, his and her welfare in the widest possible sense, not simply medical best interests. What's best for her ventilatory needs, what is best for her hematological needs. No, what is best for her generally as a person. So person-centered decision making. They must consider the nature of the treatment in question, obviously, and its likely success. But the key here is to put themselves in the place of the individual patient and ask what his attitude to treatment is or would likely to be. Consult others looking after and look at what their attitude to treatment might be. Now, it is worth us looking at these basic principles. I know a lot of you know these cases, but people don't read these quotes all the time really carefully. And actually, if you're a solicitor trying to draft a statement on a case like this for a family member, then if you root yourself in this particular patient at this particular time, what their attitudes are, and you draft a statement centered around that person and evidence and information that you've gathered about that person, then what you're going to be providing the court is an extremely useful starting point for its inquiry. And if you root yourself in that sort of principle, you can't go far wrong. So, of course, it's all from the patient's point of view. And it's a recognition that best interest does not mean that they get what they want. Best interest means something different. But whilst it's from their point of view, you can't always have what you want. And nor will it be possible for many incapable persons to make decisions. You can't necessarily even isolate and identify what their wishes are. And therefore, you're looking at information about their prior wishes, or if you don't have very much about that, about what their likes are or what their personality is like, to try and inform as much as you can decisions about what they might want to happen. So what are the principles other than that are derived from James? Well, this is a question of not whether it be in a patient's best interest to withhold treatments. Obviously, should they become necessary. The correct and fundamental question, and this is the one that's often forgotten, is whether it's in the best interest of a patient and therefore lawful to give the treatment. A lot of focus happens on the withholding, but actually clinically assisted nutrition and hydration is a treatment. It is given to somebody. The question is whether they should continue to receive it, whether it is necessary, whether it's important, whether it's in their best interest. And if the court concludes that it's not in their best interest, of course it can't consent to it. Sets the goal too high, Baroness Hale said, to look at when you're looking at futility. If you say a treatment is futile, unless it has a real prospect of curing or at least palliating the life-threatening disease or illness from which the patient is suffering. Rather, the correct approach is to consider whether proposed treatment would be futile in the sense of being ineffective or being of no benefit at all to the patient. So you can't set the goals too high. You just need to be realistic, is what this judgment says to you. It's appropriate to define no prospect of recovery. It's also not appropriate to define no prospect of recovery as to mean no prospect of recovering to such a state of good health as will avert the looming prospect of death, even if life-sustaining treatment is given. Where a patient is suffering from an incurable illness, disease, or disability, it is not very helpful to talk in terms of recovering to a good state of health. The patient's life may be very well worth living, though a life with functional inability or living with disability. And that's a very important principle underpinning the respect for autonomy under the Act. The court must be cautious about making declarations in circumstances where they are not fully predictable and fluctuating, so you need to get to a degree of settlement before you can ask the court to make those predictions. May not always be possible, but if it is, that would be helpful to get the better evidence. And the courts are most reluctant, and this is the point I started with, to lay down general principles which might guide every decision. I cannot emphasize this enough. I know serious medical treatment cases alarm people. They think, oh gosh, that's a serious case, and become a little bit over anxious about how they're going to prepare it and whether they're going to do a good job. But the truth is that you mustn't get caught up in all of the different case law. That is not what these cases are about. These cases are about the single patient at this point in time, with this condition, with this treatment. Every patient and every case is different, and it must be decided on its own facts. And that's why the role of the solicitor and the family and the doctors to gather as much information and evidence as possible on those facts is so important to the success and the use and the quality of the hearing, to make sure that the judge has everything they need. Now, a very helpful quote here by Miss Justice Hayden, just pulling some of those principles down into cases, and you'll often see this quoted. This is the Salford Royal quote: fully investigate their values, beliefs, and that sort of thing. Ascertain with sufficient certainty. If you can ascertain views, they should generally be followed or afforded great respect, though they can't automatically be determinative. So what if you have a situation where you have P who opposes or is resistant to a course of treatment recommended to them by their clinicians? Where resistance or opposition is consistently expressed, it is of course arguable that wishes should be respected, not least because of that quote I just took you to in the Salford case, and that would be notwithstanding the fact that the individual lacks capacity. Mr. Justice Hayden has said more recently in the Pennine Acute Hospital Trust case in TM that it's more likely that that will be accepted, that their wishes will be accepted, where P recognises that the refusal of treatment would lead to certain death. So in TM, you had a homeless gentleman who lived indeed on the streets of Manchester, and he had got to a situation where his condition in terms of his foot and was in a very poor state, and the ultimate recommendation, unfortunately for him, was a below-the-knee bilateral amputation, and that was, I'm afraid, his only surgical option in reality. He resisted that option. He didn't recognise, as the judge here says, he's a bit pains to point out that the life force beats strongly within him. He wants to live. He has an eternally misguided belief that he will recover without any treatment. The pervasiveness of this misguided belief contracts, and it substantially diminishes the weight that might be, in other circumstances, properly given to what was otherwise a consistently expressed wish. So this gentleman had a consistently expressed wish, but his wish was coupled with this belief system that he's going to recover without treatment. And that just was so far removed from the reality that, as Mr. Justice Hayden foreshadowed earlier in the judgment, if you have some realistic understanding that your refusal will lead to your death, the court's more likely to follow your express wishes than if you are in a situation like TM where he didn't, even if that's consistent. Another few examples there of cases in which Mr. Justice Hayden has done precisely that. He has followed the wishes of the individual, even though it would have led to a very serious consequence for them. And we know, when we've seen the very helpful case of another amputation case of Mr. Justice Peter Jackson in 2015, the Wye Valley case in B. That was a case, of course, in which a man had a mental health problems. He was florid in his delusions, but nevertheless, as a long-standing delusions, he nevertheless was permitted to not have a treatment that was being sought by the trust, which was an amputation of his leg. And he ultimately would have had very serious consequences, if not a loss of life. But he was permitted to have his wishes respected in that regard. And one of the interesting quotes that I find from that judgment, it's often not the one that's quoted in everyone's skeleton arguments, is this, that if it's the case that a fully capacitous person can reasonably decide, you know what, I don't want you to cut off my leg because I don't want to live without a leg, and I don't want that treatment, and I recognise the consequence of that is that I might die. I'm resigned to it. If that is available to me as a capacitous woman, surely the effect of a submission that says, well, if that consequence, if that incapacitous person can't balance all those rational things that Lorraine just said about why she wanted to take the decision to not have the treatment, ergo they're incapacitous, and that must therefore be outweighed by the presumption in favour of preserving life. That isn't what the Mental Capacity Act says. And Mr. Justice Peter Jackson puts it, I think it is, I think, important to ensure that people with disability are not, by the very fact of their disability, deprived of a range of reasonable outcomes that are available to others. So obviously, clinically assisted nutrition hydration, I've just put there in the slides, which, as you've heard, are going to be on the website, the relevant guidance and just where you'll find it, just explaining what that is for those of you perhaps not come across it in your practices. Those of you who deal with these cases a lot won't need very much assistance on those, but it's there for you. I've also put together just a few of the points raised in the executive summary of the guidance by the BMJ, and that which it plainly enshrines the fact that you can have an agreement as to these things, and that presumption of life can be rebutted. So going back to TM for a moment, if I may, I'm going to just divert briefly onto a capacity point in the TM case, which was quite interesting. There are many reasons why TM, obviously, ultimately the evidence settled at these 4 bullet points. He really couldn't understand the importance and significance of the proposed treatment. The precise causation for that lack of understanding could have been one of any of the following things: atrophy of the white matter of his brain, i.e. that part of it had died, that he had a depressive illness, that he may have a condition related to PML arising from his HIV. But the key is it could have been a combination of those things or any one of them. And the court was met with an argument about the question of not being able to identify the precise causative link, give rise to the presumption of capacity being maintained. It was clear in the medical evidence, though, that whatever it was of those, it definitely impaired to such a degree that he was unable to sift the relevant information. So paragraph 35 and paragraph 37 very helpfully set out, referring back to the case of, which you might know of, the King's College case in C, where Mr. Justice MacDonald in that case indicated that, paragraph 34, the need for a causal connection between being unable to make a decision by reason of one or more of the functional elements set out at section 3. Paragraph 37, however, Mr. Justice Hayden, the Vice President, wants to make it clear that it would be your misunderstanding of that section if you read it as requiring it to, in all cases, require an identification of a precise causal link, where there are various entirely viable causes available. Insistence on identifying the precise pathology is necessary to establish causal link is misconceived. Such an approach strikes me as inconsistent with the philosophy of the Act. What is clear on the evidence is that the Trust has established an impairment of the mind and brain, and that it has, in the light of the consequences I've identified, rebutted the presumption of capacity. So you don't have to go, prove X, it causes Y. If there are X, Y, Z, sorry, A, B, C, D, could all possibly cause Y, but one of them certainly does, if not 2 or more, then the presumption can still be displaced. Now, I'm just going to briefly speak to you about a case that I consider to be a very interesting case and perhaps controversial one. What if you're a capacitous person? You're about to lose capacity. And when this decision was taken in January, in fact, the decision was ultimately taken in August of 2020, but you won't find the decision reported till early January. Decision was taken in August of 2019 on an ex parte out of hours decision, but you won't find it reported until January, when the full judgment was in, because the judge wanted full legal argument and written submissions on a point of law, which I'm going to come to. This is again the Vice President. This is a situation where R was 39 weeks pregnant and 6 days, and she had a diagnosis of bipolar affective disorder, and she unfortunately had psychotic episodes. She was detained under the Mental Health Trust, and there was a separate trust responsible for obstetric care. All clinicians who'd assessed her throughout her process, even despite her detention and despite she having a number of weeks earlier stopped taking her antipsychotic medication and refused to do so, she nevertheless had capacity to make decisions as to her antenatal and her obstetric care. There was a substantial risk of deterioration, though, in her mental health at the point at which she would go into labour, and there was a real prospect that she would lose capacity. There was a risk to her physical health as well, which meant that an urgent caesarean section was quite likely to be required upon her going into labour, and for the safe delivery of her baby. And it was quite likely that if that occurred in any event, she would resist, and therefore there would be issues relating to how to deliver any support and treatment to her. She had capacity to decide whether or not to have a C-section, and she decided that despite the risks, including the risk of potential loss of life of her and her child, she didn't actually want to have a C-section. She recognised that both she and her child may die as a result of her decision. If the C-section was required, though, it was going to be minutes of needing to make a decision, and therefore she was probably going to be incapacitous at that point. So having had this advanced discussion with her, having gone through all the issues, she having concluded that she didn't want that, very unusual thing happened. The trust made an application, both trusts made an application to the court in the emergency apps list. As it happens, Mr. Justice Hayden was in the emergency apps list. And he was invited to make a decision that despite her being capacitous, effectively, when she lost capacity, he's invited to make a decision that at that point, if it became necessary, a caesarean section was in her best interest, because it was the course that was most likely, of course, to preserve her life and the life of her child. What was very interesting in that case was she wasn't given notice, it seems. There's nothing in the judgment that suggests that this capacitous woman knew that this was happening in a courtroom about her. We don't know it didn't. They may have told her. But what we have is somebody who's made a capacitous decision, and some people have gone to court now to make an application to have her required to have a caesarean section in her best interest at a point at which she loses capacity, she having foreshadowed the potential for that loss of capacity and decided not to go ahead. So she was unrepresented throughout the hearing. It was an urgent hearing. It was so urgent, it was such that they couldn't really do much more. They didn't even have time to get the official solicitor involved. So the best they could do was appoint an advocate to the court who wasn't representing her, but was arguing the other side of the case, essentially. Trust had applied under the inherent jurisdiction, and they'd also applied for the potential use of force. So the learned judge, in the circumstances that he found himself, and he makes this point in the judgment, a very, very short time to make decisions like this. It's an urgent issue. It had been left too long, and he is critical of how they had left it in an unplanned way when they knew she was off antipsychotic medication before. But nevertheless, he wasn't critical of the fact that they brought it to court, that they were right to do so. They just perhaps not have placed him in the position of having to make the decision so urgently. But they did, and he had to, and he decided to authorise that treatment for her under the inherent jurisdiction at the time. He then sought argument on, does the Mental Capacity Act apply to a decision taken in anticipation of a loss of capacity in an otherwise capacitous person? He concluded, after careful argument, and it's really worth reading this judgment, Section 16.1 does not apply. He said, of course, to the Vice President, that I'm clear that the explicit wording of the section specifically and unambiguously curtails the ambit of that section, limiting its reach to those who lack capacity. This also resonates with the further and central principle of the Act, namely that the test for capacity is to be regarded as issue and time specific. So if at the material time they're unable to make the decision. Just hold that in your mind when you think about his analysis of Section 15 for a moment. Section 15, declaratory relief. Section 30 concluded that in contrast to the powers under Section 16 to make an order, the power to make declarations of lawfulness pursuant to 15 is not expressly curtailed by a requirement of incapacity, because it enables a court to determine whether an individual lacks capacity and the lawfulness of any act done or yet to be done. The wording here contrasts markedly, Mr. Justice Hayden said, with section 16, and on the contrary, the section contemplates consideration of determination of issues of capacity. Therefore, there's nothing in the section which technically inhibits or restricts the court's declaratory powers and somebody who is assessed to have capacity. So construction didn't require it to be restricted in any way, but of course the court has to be purposeful in its construction and needs to look and protect and guard against the autonomy of those who lack capacity to make decisions. He also made it clear in his judgment that he wasn't actually being asked to authorise medical intervention in relation to a capacitous adult. I am being invited to determine whether, if the adult in question loses capacity, a medical intervention can be authorised, which is contrary to express wishes, whilst capacitous. In virtually every application that comes before this court relating to medical treatment, the answer to the question posed here would be a resounding no. The court made some very helpful observations. Do you have any cases, moving aside just a moment from medical treatment, for serious medical treatment? You have fluctuating capacity cases of any kind, whether they're treatment or care. This is a really good paragraph you might want to look at for your skeleton arguments, because it just does a little bit of explanation about fluctuating capacity, and you might find that a particularly helpful quote. The Act does, of course, and we recognise that capacity is not a static concept, and there will be individuals and situations where they're able to make a decision one day but then not perhaps the next, and manifestly it's neither practical nor desirable for the court to resolve questions of fluctuating capacity on a day-to-day basis, particularly if they relate to a serious issue like serious medical treatment that are going to require it to come back to court for that decision to be taken, rather than a decision perhaps being taken under the non-court part of the Act. So it may well be that a loss of capacity is to anticipate a likely loss of capacity is going to be able to protect P efficiently. Any declaration of an act yet to be done, the court said, must contemplate a factual scenario occurring at some point in the future. In the opinion of the Vice President and in his judgment, it does not strain the wording of the provision in any way to extrapolate that it's apt to apply to circumstances which are foreseeable as well as those which are current. There is no need at all to diverge from the plain language of the section. In making a declaration that's contingent upon a person losing capacity in the future, the court will do no more than emphasise that the anticipated relief will be lawful when and only when P becomes incapacitous. It is at that stage that the full protective regime is activated and not before. But it is an advanced decision. So what about that? He took the view, when just looking at the other aspects, remember there was force and deprivation of liberty issues. That's very difficult here because, of course, section 16, 4A and 4B are all anchored in the orders section. And we've already looked at his judgment that they are unavailable because if you have capacity in anticipation of a loss of capacity, you can't use those. So the only place to authorise any use of force would have been the inherent jurisdiction. So even if the Medical Capacity Act applied for the declaration, if you wanted to authorise force or the deprivation of liberty, you'd still find yourself in the inherent jurisdiction. The judge did consider advanced decisions because arguably this woman had made a very thought through and made her decision, and she'd made it in contemplation of the circumstances that were about to arise. And yet here we have a situation whereby that wasn't formalised in any way under the Act. The court concluded that whilst an advanced decision properly constructed with appropriate safeguards in place would, in my judgment, be binding on the court, do not, however, consider that R is in an analogous position in preparing and drafting a carefully worded advanced decision, which is compliant with the statutory safeguards. P will of necessity have been required to identify the clear circumstances which the refusal to comply is made. And he went on to look at some of the issues like the formality of the signatures, and it's worth reading if you're interested in cases relating to advanced decisions. He then, the Vice President went through all of the case law that you are very aware of, that a woman, a capacitous woman, has a right to determine her own body, her own rights. That child is en ventre sa mère, and therefore is not a human being with its own rights and individual rights separate from the mother at that time. So having gone through the case law, the court accepted and of course concluded, as it must, that the mother was entitled to make whatever decision she wanted, which would lead to the death of her unborn child or herself. When the court has a responsibility for taking the decision, however, Mr. Justice Hayden said that I do not consider we have the same latitude. It should not sanction that which the court objectively considers to be contrary to her best interests. The statute prohibits this by way of specific insistence on reasonable belief. So even if the decision is somehow unreasonable, morally repugnant, that's a dicta that you'll find by Lady Justice Butler-Sloss in the case of MB, another case in which a judge had previously ordered a capacitous woman to have a C-section. The Court of Appeal overturned that. But the important respect for autonomy remains the focus, but the court won't permit the death of P in circumstances whether she is both viable and the fetus is viable. And given that this woman had instincts which were wanting to have her baby, it was strenuous. She had a strenuous insistence on a natural birth, for example, but there was a paucity of evidence available to him because she wasn't represented, and of course there was limited information to suggest that she was motivated by anything other than honest belief that it was genuinely best for her and her baby for her not to have the intervention of a C-section. So she delivered a healthy baby boy in the end, and I end with this case because I am really very troubled by it. I've got to be honest, I consider this to have profound implications. And it isn't binding, and of course, on appellate courts, but it's a case which we have a situation which actually now has been brought into sharp focus. So somebody with COVID-19, you're very aware from your own practices, no doubt, that if that individual has a potential to have invasive ventilation or go into intensive care, they can be quite capacitous right up to the moment in which they are intubated and ventilated, quite unusually because of the nature of the disease. And you've heard it said a lot by those speaking on behalf of, in fact, the Vice President's spoken about it repeatedly, that there are much more open conversations about what you would want and how you want to be treated when you go into intensive care, how long you want to be ventilated for, what do you want us to do if this happens. Those are full conversations that are now taking place on wards all across this country and have been doing so for the past year. And then there have been situations where, okay, the person then through their disease is rendered incapacitous because of the loss of oxygen, and they need to then be ventilated and they need to be supported for a period of weeks. If that person in those discussions makes an entirely capacitous decision, which they've weighed up all their options and they've thought about it, let's take me, let's say I get COVID-19 and I've made my decision that assuming I'm pregnant, I don't want a cesarean section. I recognize the baby might die. I recognize I might die, but I've weighed it all up. I've listened to all your debates. I've decided I'm not going to do that. I recognize that I now need to be ventilated because of my COVID-19. I then ultimately deteriorate and I'm ventilated and taken off to ITU. And somebody goes to a courtroom and asks the judge to reverse a decision I made beforehand. That has profound implications across the board because there are so many different diseases, there are so many different conditions in medical treatment where a person is on a deteriorating path unless the treatment intervenes to support the person to improve their circumstances. What we have to ask ourselves is this decision essentially means that whilst they're well, in contemplation of that deterioration, they make a decision and they talk to their doctors and they decide how they want it to go, and they make the very hard decision that we don't always approve of, but they do, that they're not going to have that treatment. Is it the case that once they deteriorate in every case, we can just go past that, take it to the Court of Protection and seek a decision under the Mental Capacity Act under Section 15(1)(c)? On the basis of that decision, I think it sounds like you probably can. And any attempts to limit it are very difficult when you apply the principles that have led the court to that conclusion. in my opinion, humble opinion, don't suggest I'm right, but I am very troubled by it. And I think that it's one of those cases where we might find it eroding, in fact, the autonomy of the individual. Now, I very rarely finish on time, and I didn't. I'm 2 minutes over my 45 minutes talking to you, but I believe there are opportunity for questions.
Just while I ask people, we have a question already, but just while I ask people to use the toolbar to do that, Lorraine, and just perhaps want you to elaborate on the Guy's case, because it begs the question of what's the point in advanced decisions, doesn't it? If they're just going to be overturned at the point of incapacity. I've not heard of this case before, so it's very interesting, but it's difficult to square a very considered decision whilst capacitous with what's happened in this case, isn't it? It is quite troubling.
I'm troubled by it, but that doesn't mean that there isn't a proper set of circumstances in which it can be rationalised and it can be properly justified. What I'm troubled by is its implications for lots of, as you've just pointed out. Yes, of course, advanced decisions properly done under the Act when people have got the relevant time to write them down and they have
the paperwork.
And the paperwork's done.
Yeah.
But we all know how onerous that paperwork is, even for an advanced decision. And so what we have found over many years, and you know, we've all, I think, been energized by the level and quality of clinical discussions taking place during this pandemic with people, and them being really, really in tune and being decisive in their future care as to what they're willing to tolerate, what they're not willing to tolerate. I consider this decision as potential to erode those conversations between doctors, and doctors respecting that, writing those down, patients maybe just, you know, agreeing them, and they note them in the notes. They don't always sign them. But these are not formal advanced decisions, but they are decisions taken in the heat or the rush of the moment, but they've nevertheless had enough time to weigh the matters up. I'm very concerned about that. And I don't think that, I think if we have a stringent or a rigidity to the prescription of advanced decisions, what we do is we undermine those discussions that with doctors that really are the day-to-day bread and butter of clinical care. And it's a real issue. I think what I would say is, as if you remember when we were all law students, I remember the debate about the MB case, horrified that a capacitous woman was said to have a cesarean section, though she didn't want it. And I was horrified. But of course, what you have to recognise is this decision, this very reasoned judgment, wasn't being made on the day. The judge had a case before him, a woman about to be in labour and a mother and a baby about to die. And that's the evidence.
Morally, it's probably the right decision, Lorraine. It's just the way you do it, isn't it?
Yeah. And so I can understand how that's come to pass. Where I struggle is the very point you've just highlighted. You know, what can we now use it for? And where does that work for, you know, my autonomy as a woman if I make a decision like that? I really struggle with the idea that individuals can be in a courtroom in London and I am in a hospital having made my decision, and I don't know about that decision being made and a judge authorising as soon as I lose capacity to override it.
Yeah.
I struggle with that.
Yeah. So going on to the questions, what are your views on whether do not resuscitate decisions amount to serious medical treatment and therefore needs an IMCA involvement in light of the Resuscitation Council guidance, and the MCA makes no distinction between best interests and futility?
Yes. My own view is that it's serious medical treatment because the life of the person is in peril in that moment. And I recognise that there is no clarity on this, and I recognise that that's why you're asking me the question. If you want my instincts, that you know, if you go back to the definitions I was talking about before about serious medical treatment, sorry, you're now seeing the whole workings. It looked so smooth before, didn't it? But if you go back to the definitions, are the only one we've got under the Act here. You know, this is it's a serious consequence for the patient. So why would it not be serious medical treatment? So I think you have a very good basis for seeking to argue that it is, but be careful that if you're putting applications into the court, that you fully rationalise why you say it needs to go to a tier 3 judge and follow that sort of serious treatment urgent protocol, rather than be the gatekeeping decision elsewhere. I don't know if I've answered the question, sorry.
Thank you. So I share your concerns with Guys versus R, not least because of the lack of support P had to take part in the proceedings. Well, she didn't take part in the proceedings at all, did she? And also to draft a valid advance refusal on healthcare. It also moves against the direction of the travel in the UNCRPD. Do you think it will erode the autonomy of people generally, or pregnant women in particular?
It's my fear that it erodes the autonomy of pregnant women. And it's my fear that because of the complexity of that type of medical treatment, where inevitably the human being making those decisions is also concerned with the fact that you have a viable baby to be born. But the reality is that that is not a life that is separate from its mother's. It's en ventre sa mère, and that's her decision to be taking. And if she can take it, she should. And we all know that. We all jealously guard that aspect of the law. I know I've argued it in many cases before the courts, as we all do strongly. And there is a real danger that because it's such a highly emotive area, women and birth, that will mean that there are more disproportionate decisions made which are overly protective in that area, which does erode the autonomy of women. I have to be cautious, of course, because Alison Alison, one of the most experienced mental capacity solicitors and does a lot of medical treatment work, hadn't really become aware of this decision. I suspect a lot of you hadn't had it on your consciousness. It's not been a decision that has been elevated to a principle that is being used and applied. And I wonder if that is because, in truth, a bit like the MB decision, there are a number of procedural difficulties with the decision that mean that the woman's case wasn't argued properly before the court. It was argued by, don't get me wrong, there was an argument, was an advocate for the court. There's no suggestion 1 minute that the proper points weren't taken. It's obvious from the judgment that there's a lot of law in there. But nevertheless, that advocate to the court wasn't representing her, wasn't fighting for her autonomy. And in those circumstances, that there are procedural issues with that case. And also there are other issues relating to, whether the decision can be one of those where we just understand it being taken in the context in which it was taken, the very specific, highly stressed factual scenario of an urgent decision being required. And it may be that that's why we're not seeing it applied broadly. So I haven't got fears, in truth, that it's going to be applied broadly, but I do have fears that it can be used to erode the autonomy of individuals. And I'm drawing it to the consciousness of you, in case you weren't aware of it, because I would like you to be thinking and wrestling with these issues if you ever get those cases, and just be aware of the structure of that judgment.
Thank you, Lorraine. The next question is, can you talk to decision-making on a case where family wish for COVID vaccine administration for a relative with an LD who would be resistant and then would require physical restraint, something that we've come across quite a lot in the last few months?
Yeah, now, I know Eleanor, in fact, was speaking about vaccines earlier today when you had one of your others. And one of the things I would say is, just so that I'm clear, there's a debate about whether it amounts to serious medical treatment. I think we're coming to the position where it probably, vaccination itself doesn't necessarily amount to serious medical treatment. So the court is going through a tiering and gatekeeping decision making. That's why I think there was a recent decision of His Honour Judge Butler, a Tier 2 judge, making a vaccination decision. And you've seen 2 decisions by Mr. Justice Hayden making vaccination decisions, but those were the early ones. You would always expect them to be drawn to his attention. What I think is the scenario you've just proffered is bound to be considered one of the utmost seriousness, because it has that ethical dilemma of force being used for somebody who is, naturally objecting to vaccination. And you only have to add the fact that some people have lived their life refusing vaccinations or rejecting conventional medicine. And their values and belief systems are really important. And the element to which one has to consider public health within the best interests of the individual, and the altruism that is sort of, if you like, imposed upon humans, that if you don't naturally have it, that you are to look after others, and you're to think of others as well, because your own safety can be impacted by others. That is an element of best interest, but it's going to be very carefully weighed on the facts. What I would say is the issue of the use of force to give vaccination, if it's going to have the consequence of sparing that individual with learning difficulties from a potential for serious illness as a result of COVID-19, then the use of force and the proportionality of it may be justified, but that would need to be very carefully looked at. So I would be looking to start in a scenario like that with proper medical opinion about, first of all, the P's likelihood of serious illness, or what type of illness, what the likely consequence, what's the likely impact of COVID-19 on P, if he got it, if she got it. Then you want to be looking at the epidemiological evidence. So if I was going to take a case like that, I'm afraid, unlike the other cases that come before the court, I'd be looking to get proper expert evidence in place before I applied. And I'm afraid that sort of case is going to need to be tested by the Vice President. And I get, I'm on the hive. So we know that these cases are coming, and we know that there's going to need to be a lead case on this at some point. Yeah. And it's undoubtedly the case that, as you've seen already, the Vice President's taking those that are on those questionable areas to make sure that when the right case comes, he can give the judgments to help you navigate this difficult period of time with vaccination.
It'd be very helpful to have that definition, wouldn't it, in this area?
It would, and we're just going to have to find the right case. But the truth is, on a case like that, where somebody is objecting and force is going to need to be required, the real balance is the proportionality of that interference, not just the vaccination as well. And balancing that is going to require a proper baseline as to what the risks are to P, not just to the rest of the population of his care home or his supported living.
Yeah. Thank you. This is a very interesting question. Would the judgment, about the Guy's case again, Guy's and R, would the judgment not have been different if the mother's life only was at risk and not the unborn child? Is it not this element, i.e. the risk to the child, which has swung this decision?
I can see where you're coming from. I don't think it. No, I don't think it does. I appear a lot in front of this junction, so I've got to apply that mindset as well of what I know about how he makes decisions. I don't think the baby itself will have been the thing that swung it. I think the immediacy of the potential loss of life of somebody, a young woman who could be saved and to be with her baby, and even if there was no baby, a young woman who could be saved, that there's always the potential that the overprotectiveness comes in when you have obstetrics and issues related to cesarean section. You've seen the academic articles on this issue. We know it's a factor we have to guard against in these cases. We have to be really vigilant about. But I equally think that given the rationale, given the reasoning, in a late list, I don't know whether it was late in the day, but it was certainly the emergency applications list, and there was certainly not enough time to tell the woman and get the official solicitor and get everyone in court. So if that's the scenario that you're dealing with, then you're talking about a woman who might die, and you can save her very simply with a cesarean section. I can't be convinced that wouldn't be simply just about her life. So I don't know, but I take your point. We must jealously guard against this over-protection of women and over-paternalism that can creep in to obstetric decision-making. I'm entitled to decide what happens to my body, and I'm entitled to decide what happens to any baby that I'm carrying. And even if I'm capacitous at that point, or I'm about to lose capacity, I should be able to manage those decisions myself, and that's my view. And I'm troubled, as I've told you, by that case.
Thank you. I just have one more question. Did the woman's challenge to the decision to the NHS Trust go to the COP? If not, does she have a right, as a human rights, have been eroded?
Arguably, there is a human rights claim there, yeah. That's all I can say. I mean, we can all see the logic as to why that is. At the end of the day, though, and this is what I find the most interesting part. I find the law interesting because I'm a nerd. People say I'm a law nerd, and I am. That's the truth. But one other aspect I find really interesting was, isn't it right that this woman knew her own body? She actually was right. She wanted a natural birth. She knew it was right for her and her baby. She decided she didn't want to be cut and have any C-section. And she had, whatever it was, a real sense in herself that it would be okay, even though she recognised the risks that she was running and that it wouldn't. And she was right. And, why is that in any way eroded? Because she has mental health problems, has a disability, has these sorts of difficulties that maybe she can't articulate all of the things. It sounds odd, doesn't it, that we might know our own body, we might just be right. But isn't that every part of a human being when we make a medical treatment decision? Sometimes we have a little bit of hope, or sometimes we just want to believe, or sometimes we put our faith in God. These are our personal choices to make. And an ex post facto rationalisation of why she would have made it what the rational thoughts were is not what this court did. But even if it did, it wouldn't have necessarily hung together objectively as an evaluation under the best interest decision making of the Mental Capacity Act. Sorry if I'm conflating points.
No.
So I find that very interesting. And I think that's part and parcel, isn't it? It's really important about personal decision making. That person in that time, in that moment, in that decision. Yeah. And that's why I've woven the slides. As you can see, I've tried to show you all of the dicta and how this just jars with it a bit.
Yeah.
Because it wasn't that person in that time making the decision.
Yeah. Thank you. That's a point we'll all take away actually from this talk. That person at that time, that specific person in those circumstances. I think that's something sometimes that we get lost in it all, and that's the really important nub of it all, isn't it?
And if we root ourselves in our evidence like that, I mean, I think a judge would be delighted if what they get are statements that are rooted in those basic principles. Try not to fret when you're preparing these cases about, oh, they're very serious or very legally complex. No, they're not. They are factually complex. And actually, that's why there's a huge reliance on really skilled solicitors to pitch these cases the right way. And that's about really gathering as much information as you can and probing your clients and anywhere that you can get resources, emails, texts, anything that you can show that would illustrate what that person would do in this situation.
And on that note, thank you so much, Lorraine, for a very interesting talk as usual. Thank you for your time, and your slides and the information you've given today will be on our website. So thank you very much indeed.
It's a pleasure to meet you, Alison. Take care.
And you. Bye-bye.